we have to get a little geeky today to talk about whether or not there is a two-part test to NYSRPA versus Bruen, despite the fact Bruen said there's not a two-part test. Super geeky, worth getting into. Let's chat about it when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of many books, including Disarmed, What the Ukraine War Teaches Americans About the Right to Bear Arms. Stay tuned for a very quick announcement very soon about the next book. Very, very soon. I just submitted the book back to the publisher for typesetting, so we'll see what happens next. All right, folks, so here's the story. This is not the hottest topic on the planet, but it's important for you to understand this because it's the sort of thing that the anti-gunners try to play fun with or have games with in their discussions in scholarly articles. Some of the judges, like Judge Eastbrook, like to make fun of the Supreme Court to try to undercut the credibility and integrity of the Heller and Bruen methodology, which is text first, burden shifts to the government, and then historical analog approach to the interpretation of the Second Amendment. So this is really I would say a straw man kind of argument. It's just kind of a silly semantic game about what I'm going to describe, but I want you to understand this because to be the smartest person in the room, I want you prepared for all sorts of snarky, sarcastic comments made by any anti-gunner, so you're designed and you're trained to fight back as a force multiplier to advance the right, all of our rights to keep and bear arms. Okay, so as you may recall, in 2008, the United States Supreme Court decided the District of Columbia versus Heller case that engaged in the following methodology of interpreting the Second Amendment. They start with the text of the Second Amendment, they defined all the words of the Second Amendment, and then what they did is they then looked to see were there historical laws associated with firearms regulation. In the case, the Heller case, where we're trying to assess whether or not a handgun ban by the District of Columbia was constitutional, they found that it was not. They looked at the text of the Second Amendment. They concluded that arms includes anything that can be used offensively or defensively, which obviously would include firearms. So at a textual level, the handguns that were banned by the District of Columbia and Heller were obviously implicated by the plain text because they were an arm that was banned, and thus the right of the people to keep and bear arms, i.e. handguns in that case, was infringed because it was hindered or destroyed by the District of Columbia's law that said no handguns in D.C. if you're an ordinary civilian. So textually, there was violation of the Second Amendment. Then the Supreme Court went on and said, we're going to look to see if there's any historical laws that would justify any kind of restriction whatsoever of handguns or anything like that. And they came up with a couple historical traditions or regulations or things that they thought might be relevant. One was they looked to see that Americans had a duty to bring their privately owned firearms that they commonly owned in their farms or whatnot to militia musters under, for example, the Militia Act of 1792. It wasn't the only militia act, but it was one, of course, it's obvious that came up. It's a federal one in 1792, 1 year after the adoption of the Second Amendment in 1791. And then they also looked to see that there was a tradition of banning the carrying of what were known as dangerous and unusual weapons. And the Supreme Court said in light of that gestalt of history, it was pretty, again, not just random history, but historical laws. Notice there was laws dealing with militia. The Militia Act of 1792, that was an actual law. It wasn't airy-fairy history told to us by some Ivy League professor. Likewise, the common law, long-standing common law that I think was discussed by Blackstone, the English commentator, of the banning of the carrying of dangerous and unusual weapons. Again, another set of laws, in that case common laws, and the Supreme Court said the one thing we can say for certain based on that historical tradition of regulations that we've just gone over, one thing we can say unequivocally is that Americans commonly owned arms that they commonly use for lawful purposes cannot be banned. Now, there may be other ways that the right to keep and bear arms are protected. There may be other reasons for different kinds of arms bans to be knocked out, but the one thing unequivocally that is sufficient, again, sufficient for knocking out an arms ban case is if a particular arm that's being banned is in common use by Americans for lawful purposes, because if it's in common use by Americans for lawful purposes, it cannot possibly be dangerous and unusual, because it cannot be unusual, and if it cannot be unusual because it's in common use, it cannot be dangerous and unusual. Okay? Very straightforward. Now, in addition to That's what Heller said. Then, of course, we get to the Bruen case. Again, let me step back for a second. Between 2008 and 2022, when the NYSRPA versus Bruen case occurred, what happened in that window was that the lower courts that dealt with gun control regulations began to invent a test that was specifically repudiated by the Supreme Court in Heller in 2008. The way the anti-gun judges in America dealt with the Heller case was by trying to ignore it and rewrite it. And the way they did it was as following. Hear me out, because I want you to understand how the two-part test that the Supreme Court criticized in Bruen that arose between Heller and Bruen is a different sort of test than what has arisen after Bruen. And I want you to understand the difference here so you don't get tripped up by some anti-gun snarkiness or sarcasm about two-part tests in the Second Amendment context. Specifically, between 2008 and 2022, what the anti-gun movement judges did was this. And remember, as a reminder, all of these cases arose, or virtually all these cases arose, in the anti-gun blue jurisdictions, because again, keep in mind, places like Texas and Florida generally do not have terrible anti-gun laws. I'm not saying they're perfect, but as a general matter, if you're looking at the really bad jurisdictions, California, New Jersey, Illinois, New York, etc., Hawaii, guess what? Those are the places that have the worst gun control laws, and they also have the worst anti-gun judges, because the same politicians that enact those terrible anti-gun laws in those terrible deep blue jurisdictions are the same anti-gun politicians that have a major say, if not the say, in picking who becomes the federal judges overseeing that part of the country. So Chuck Schumer, in addition to having a say about New York State gun control laws because of his status as the head of the Democratic Party in that state, he also has sway over who becomes a judge in New York State on the federal bench and beyond. So the same people that are supportive of the Chuck Schumer anti-gun agenda, as a general matter, find themselves on the federal bench overseeing legal challenges of the same anti-gun laws that people like Chuck Schumer and other politicians like him enacted. So you can see the problem. So as a consequence, between 2008 and 2022, what happened was there was a two-part test that was literally invented out of whole cloth. So what the anti-gunners did was basically this, and I'm going to summarize it generally speaking so you get the gist of it. There'd be a legal challenge to a gun control law under the Second Amendment, and these anti-gun judges would say, okay, well, the first thing is, does this law implicate the Second Amendment? And the answer is no, then the case is over, okay? If the answer is yes, then all they did is they said, okay, then we're going to pretend it implicates the Second Amendment, and then what they're going to do is they do a step two, which is to say we're going to do interest balancing tests in the form of intermediate scrutiny or something like this. And what they basically say is, we understand that that gun control law is implicated and infringes upon the right of the people to keep and bear arms and thus implicates the Second Amendment. But then they do step two, and that step two is, okay, is that law, is that right, the right of the people to keep and bear arms, really worth insisting upon here, or has the government set forth such a compelling reason for this gun control law, like stopping mass shootings or stopping crime or whatever it is, that even though we think there's a violation of the Second Amendment on its face, at step two, we're going to ask ourselves, is the right really worth insisting upon or not? And that's where the problem. So they do a Second Amendment analysis, which is generally speaking very sloppy. That's what the anti-gun courts did. And then they did step two and said, okay, even if it violates the Second Amendment, we're going to balance it away by saying that the compelling state interest of stopping mass shootings or stopping crime or whatever it is so important as a governmental interest. It's so important to protecting the public from that potential harm from guns. We're going to ignore the Second Amendment and allow that violation to occur using strict scrutiny or intermediate scrutiny or tiers of scrutiny or any of these kinds of euphemisms, which are nothing more than interest balancing tests that says that, hey, judge, you get to decide whether or not the Second Amendment right's really worth insisting upon here, or if the compelling state interest is so important, you can basically allow for the violation of Second Amendment rights on the part of American citizens, and thus they lose their rights. That's how it worked. Now, Bruen came out and said that that's one step too many. The Bruen court said that that second part after there's an analysis of whether or not there's a violation of the Second Amendment, then they go on to say that second step of basically interest balancing or intermediate scrutiny is one step too many, and thus all that interest balancing is totally unacceptable in the Second Amendment context and should be thrown in the trash heap of history when it comes to the Second Amendment and never done again. So what the Bruen case did in 2022 was essentially to reaffirm Heller and then go on to say, as we said in Heller, and now we're making it super, uber clear that there is no more interest balancing ever again. And thus, that's why the Supreme Court in Bruen made the comment that says that the two-step test of is there a violation of the Second Amendment, step one, yes or no, and if there is, whether or not there's a compelling state interest that would justify the violation of that constitutional right, the Supreme Court said in Bruen, that's one step too many. The only thing that should take place is whether or not there's a violation of the Second Amendment. If the answer is yes, then that's game over. The law is unconstitutional and the Second Amendment proponent prevails. There is no step two in terms of interest balancing. Now, what's happened is, and this is where the game gets played, the anti-gunners, scholars, and some others like to make comments like, well, Bruen really has adopted a new two-part test. But that's not really true, and in some ways, it doesn't matter because it's semantic. The reason why they say this, and this is why I want you just to be aware of this, is because if you break down how you analyze a Second Amendment case, in one sense, it may be two steps, but it's a far different two-step process from the two-step process that existed with tiers of scrutiny before Bruen. And what I mean by this is this. The two-step process that now exists, if you want to call it that, is really sort of a two-step process in the following way. The first step is simply you look at the plain text of the Second Amendment, and if the modern-day gun control law is implicated or implicates that text of the Second Amendment, the right of the people to keep and bear arms, once it's implicated, then the Second Amendment analysis really occurs, because the step one, you're really just talking about a pleading requirement that says this is a gun control law. It hinders the right of the people to keep and bear arms, and therefore, guess what? It violates the Second Amendment, and that's it. The burden shifts to the government, and then that step two, if you will, is whether or not there is any historical analog laws on the books from the time of the founding in 1791 to justify the modern-day gun control law. So really, in many respects, the whole fight about Second Amendment cases today is where the burden shifts to the government to establish whether or not there is a historical limitation on the right of the people to keep and bear arms. So in some pedantic sense, it is two steps in the sense that step one is the text of the Second Amendment implicated? But that's really a very de minimis kind of pleading standard situation. The real analysis of the Second Amendment occurs at step two, where the burden of proof is on the government to show there's longstanding historical analog laws. Again, the example I like to always give, just to illustrate the point, is if you have a law that says you cannot commit cold-blooded murder with a gun, well, that's something that's understood, and you could not assert a Second Amendment defense to engaging in cold-blooded murder, because even at the time of the founding, you could not engage in cold-blooded murder with any kind of arm, including handguns, even though they adopted the right of the people to keep and bear arms shall not be infringed in the context of the Second Amendment. So that's the kind of thing that the Supreme Court says we have to look on the books to see if there's something long-standing like that, and if there isn't, the government losing the gun control law goes away. So again, when you hear people say the Bruen test is still a two-part test, that's conceptually true, but really it's a matter of semantics, because the two-part test that occurs is really the plain text. Is it implicated, yes or no? If the answer is yes, then the burden shifts to the government to do step two, if you will, or the second part of it, which is whether or not there's a historical analog set of laws that justify the modern-day gun control law. But to me, I think the way to reconcile this is really to say that the plain text analysis is not part of the Second Amendment analysis beyond it's simply a pleading requirement. The real Second Amendment analysis that takes place, that one step, is the historical work, and it's not just any historical work like we try to find a historian to come out and tell stories about anything. It's whether or not attorneys and judges can find historical analog laws on the books that are analogous to the modern-day gun control law, and if they can't find that analogous set of laws, where the how the laws were implemented and enforced and the why they were implemented and enforced, and make sure that the how and the why line up in 1791 with what happens with the modern day gun control law today, then that's it. That is the one step. It's the historical inquiry of historical analog laws. That is the Second Amendment analysis. It's not the two-step thing we talked about pre-Bruen that the anti-gun courts came up with, which again, is there a violation of the Second Amendment? If the answer is yes, well, we can still allow the government to do it if it's a compelling state interest and justified in some sort of way. We can interest balance away the rights of the people to keep and bear arms. That second step, pre-Bruen, is a no-no. That is what the Supreme Court was talking about when they said two-step, the two-step process that these lower courts made up was one step too many. The real fight is, again, at the historical level, as Bruen articulated. And again, the Bruen methodology of text and then history is the same interpretive methodology of the Second Amendment we saw in Heller in 2008, which again was text as defined by the Supreme Court, and then history. So it's all the same thing. But again, sometimes you will see anti-gunners say that there's still two steps going on. And yeah, there may be two steps pedantically or as a matter of semantics to the extent you want to say plain text is step one, historical work is step two. But that's not the sort of two-step process that Bruen was criticizing, which is, again, that second step being interest balancing away the rights of citizens, even if the government violates the Second Amendment right. So I hope this clarifies some things you may see out there on social media and some comments, sarcasm out there by the anti-gun movement, but this should clear it up. And again, the bottom line is this, that the Bruen methodology is very good for us. The tiers of scrutiny analysis is very bad for us. We can do a lot more discussions of that if we need to, but the reality is the tiers of scrutiny interest balancing is dead in the water for the moment. As long as this current Supreme Court exists and will enforce their laws and their precedents, we'll see what happens this coming term. But again, I'm optimistic that ultimately the Supreme Court will step up and defend the Heller and Bruen methodology and precedents. But again, only time will tell to see if I'm right, but I think I will be. All right, well, there you have it. Hope you learned something here today at the Four Boxes Diner. Don't forget to subscribe and resubscribe. Don't get knocked off the list. Don't forget to follow me on X at Four Boxes Diner, and we will see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.